We're live.
Doing this.
All right, welcome to Legal Tech Week. This is Bob Ambrogi, and we're trying something a little bit different here today, which is we are not all in our little Brady Bunch Zoom boxes here. We are all on stage together. As it happened, we were all at Relativity Fest this week, and the folks at Relativity have very graciously, as you can see by our backdrop here, given us a nice little space to get together and do our panel live here today. I'm looking out as though there's an audience in front of me, but there isn't an audience in front of me, so it's a little.
No.
Well, we have an audience.
A small audience.
All right, there we go. So this is going to be a little bit of experiment, and we hope it all goes well. But let's start as we usually do by introducing who our panelists are today. So let's start with Joe.
Joe Patrice from Above the Law and Thinking Like a Lawyer. And I am here live in front of a real audience. Not a huge one, but a large, but an audience, you know, and obviously the large audience watching us online.
And Steve?
Hi, I'm Steve Embry. I write the blog Tech Law Crossroads, and I will say that we have a very engaged audience in front of us.
All right, and I'm going to skip you, and then I'm going to go to Stephanie.
Yes, Stephanie Wilkins, Editor-in-Chief of Legal Tech News at ALM, and we assume you're out there. So this is a little weird feeling, but we assume you're watching.
All right, and then to my left is somebody who's been on this show from time to time, but who is like the face of Relativity Fest, I feel like. Mr. David Horrigan. David, introduce yourself.
Hi, I'm David Horrigan. I am Relativity's Discovery Counsel and Legal Education Director, and this is one of the days when I get to go back to being a journalist, because I was one of Bob's reporters at the National Law Journal many years ago. So thank you, all of you, for letting me join, and Bob, thanks for letting me be here.
Thanks for being here, and I should have called you Counselor Horrigan in the spirit of your introductions. I feel like I'm paled in comparison to your moderating abilities. You've been How many panels have you done this week?
I have done 8, but I was on one of them. 2 of them I was only a guest, so 6 of them were ones that I put together, moderated, and developed. But so 8 total.
This is over the course of 2 days.
Yeah.
Only a guest.
Only a guest, right?
Whoops, sorry about that.
All right. Well. We got a few things to talk about, but obviously since we are here at Relativity Fest, we're going to start by talking about our impressions and some of our takeaways from Fest. And David, since you are a guest today, I don't know, you want to kick us off with some of your thoughts and impressions and how the last couple of days went and what were the highlights for you?
Sure. My biggest thing every year is the judicial panel. This was our 11th annual judicial panel, and for those of you who were there, we did a 180 this year. We have always tried to make it strictly about the law, strictly a lot of times about technology, but we branched out. And as I told the audience this morning, what I've always said is stay away from politics. Courts aren't supposed to handle political questions, and it's not really what we're here to do. And I didn't really go into this level of detail, but no matter what you say in today's climate, you're going to piss off 50% of the population. So it's better to avoid. So we did a 180. This year it was the 11th annual judicial panel, free speech, politics, free speech, and the judiciary. And the judges were great, as they always are. Our newest judge was Judge Allison Goddard. She's been to Relativity Fest before, but this was her first time in the judicial panel. She is U.S. Magistrate Judge from the Southern District of California out of San Diego. A great new addition to the panel. She brought a perspective. Judge Matthewman, who has been here for many years, that's Judge William Matthewman, U.S. Magistrate Judge, Southern District of Florida. Also, Justice Tanya R. Kennedy has been with us for several years, had a great perspective from New York. And then Dr. Victoria McLeod, who has been on the bench for 18 years, recently retired, but still active in things, gave us the UK perspective, which was great to have because the more they change, the more they stay the same. But a lot of the issues that we face in the US, the UK is facing as well. And of course, someone who's been with me for all 11 of them, US District Judge Xavier Rodriguez from the Western District of Texas, he had some great takeaways. And one of the biggest themes was educating, you know, it's Relativity Fest. There's a lot of educational sessions, but it was really educating people on what the law is and civility and realizing that these judges are people. And they talked about technology can do wonderful things, but technology can make things difficult. Namely, we've got Steve Tanner, who runs the social media operation at Relativity here. Social media was one of the big issues. Judge Matthewman mentioned that before you at least had to go to the post office to send a nasty letter or go protest somewhere, but anyone from anywhere can send something to a judge, calling judges this. So that was a big takeaway, but we were glad to have some great audience participation, and I thought the judges did a wonderful job of bringing home issues that you don't often get to hear at a legal technology conference, so I was really pleased with it.
Great. By the way, I should mention, for those who aren't here in our massive live audience, that we can't see the chat like we usually do, but we have...
Not to panic, everyone, but there is some, you guys are frozen on the chat.
Amazing.
Not anymore.
Okay.
All right, yay!
Not on mine at least, okay.
Okay, you can see, can you see us? We have one person on the Zoom here in the room with us, so she's going to keep an eye on the chat. If you have anything that you want to ask us directly as opposed to chat among yourselves, she'll call it out to us.
And now's your chance to talk about it.
Becoming very ideologically active, speaking at ideologically aligned events, and that he felt that was doing a disservice to the concept of the judges as not personal political actors too, which I thought was an interesting start to a much broader conversation that we didn't have time for, which is how do you protect the sanctity of the judiciary as something that is not personal and political, but rather focused on the law, when you have judicial act and avoid bad faith actors in the judiciary taking advantage of that, the fact that you aren't supposed to criticize them, to, you know, take that ball and run with it, which that's the hard line that I could go like another 3 or 4 hours of listening to them try to navigate.
Yeah, and it seems to be happening more and more, and it's hard to draw the line because, you know, there are judges out there giving speeches to educational kind of associations, and they're talking about their opinions. And, you know, I just saw today, and there was a discussion about how far the Chevron holding was supposed to go. And I didn't read it, but I thought that seems to be getting kind of close to the line where you like shouldn't be talking about it. But I'm not a judge, so.
I was interested. There was some conversation, some criticism, I guess, of the Fourth Estate by some of the judges on the panel, and some criticism that the journalists. I mean, part of the problem, obviously, is that there aren't as many journalists directly covering courthouses as there used to be, and so they don't get that knowledge of the judges, that knowledge of the courts, that knowledge of the cases. But I know in Massachusetts, where I am, I happen to serve on something called the Judiciary Media Committee, which is kind of this almost like mediation committee between the judiciary and the media, where if an issue comes up, this committee can get together and address it, an issue of access perhaps, or of misreporting or something like that. And there's a dialogue between the judiciary and the media on a regular basis. We don't meet all that often, but it's a continuing program. It's been in effect for, I don't know, 20 years or so in Massachusetts. I've been on it for 15 years, I think. So I was wondering whether any of the judges on the panel, I would be curious to know how pervasive that kind of thing is, whether they're doing anything to try and interface with the Fourth Estate more than just feel like they're, you know, getting misrepresented by them or something like that.
I'm not going to name particular judges, but some of them have been more active with the media than others, and some have been more active with social media than others. And given the climate, that has backfired on occasion. And as this panel knows, there are a lot of states that have issued regulations on what judges can do on social media, whether it be court decisions or ethics opinions. But that's a good point. I thought, Bob, to your question, one of the best takeaways was what Judge Rodriguez said about how he closes a decision with a conclusion that can be not necessarily copied and pasted, but something to nail it all down and take away. Now, I think the many lawyers sitting here would say, well, that's dicta, it just doesn't matter. But that summary is something sort of like a keynote, I suppose. Stephanie, you've got the lawyer journalism thing going on. What do you think?
I mean, dicta's the fun part, right? I mean, it's fascinating to me, though, that, I mean, there are judges that would think about it so much to actively change an aspect of the writing of an opinion because of social media. And like, it doesn't impact the case, it seems, or whatever, but I just find that it's fascinating that social media has become that pervasive up to the judiciary.
And two or three of the judges did recognize that the state of the journalism today, with so fewer journalists and so fewer really sort of local publications, was affecting the reporting, and they seemed sort of to be understand that, and they didn't have a solution for it, but they understood that that is a problem, and so it's not totally the Fourth Estate's fault that things get wrong.
It's the private equity companies that own the Fourth Estate. But yeah, no, it was there was definitely a point raised that it was almost borderline unethical for a publication behind a paywall to be doing this sort of journalism because it keeps that away other than a headline. That was raised on the panel too, which I thought was, as writing for a publication that doesn't have a paywall, I thought that was worth
So that was
applauding.
one panel from the last couple of days.
That's true.
How many were there, David?
Clearly, the best panel, though, was the State of the Union, right?
Yes,
All
I-
right.
I was-
Yeah.
I was going to jump in on that one too, yes.
Yeah, I mean, they had really some stellar people on that panel, I thought, and
Impressive. The people sitting closer to stage, the stage. Yeah, it was closer to the moderator were even better.
the ones in the
Yes.
higher tiers.
Yeah.
Yeah, so for those who weren't there, it was, well, David, you organize it. He does it every year and keeps us on our toes because the format changes, but it was super fun this year, I thought, if you wanted to explain it.
Well, hey, thanks. Yeah, and not that anyone is immodest here, but the majority of this panel was on that panel. What we did was had three groups. We had the industry associations, ILTA, ACIDS, and EDRM. Then we had practitioners from Reed Smith and some other, and Scott Milner always does a great job, Stephanie Clerkin. And we also had a group discussion where, so you've got the media, the associations, and the practitioners. And we made it sort of a contest. And one of the things that was fun, granted, sure, there was a lot of AI, but I thought the plaintiff defense bar debate going on was a fun one. And especially when it comes to e-discovery, Stephanie Clerkin represents a large plaintiffs firm. And so that was a fun discussion. And of course, all of you had great things. And Bob, I'm not going to say that you brought this on, but you were talking about lawyers and how they can have incompetence problems. And I don't know if they were just trying to get back at you or what.
But yeah, so I mean, there were 10, 11 of us up there, and we each got a few minutes to say what we thought the biggest development in the past year was with e-discovery. So it was a big range of opinions, and amazingly, we managed to not overlap with multiple different AI topics. And the media group, which we were all on, we were sitting in higher chairs, like literally taller chairs. So clearly,
You're welcome.
yes, clearly, our position was elevated and we were set to win. But everyone was a winner because it was all for charity. But I thought it was really, really fun. I mean, having that many, it was an impressive feat to fit us all on the stage to begin with, but hearing that many different perspectives all in a row, and it was standing room only. They were turning people away from the room. I had such a good time on that this year.
So this is a legal tech podcast. And
Yes,
we may want to talk about legal tech a little bit.
sure.
And a couple of the big announcements, I guess, this week here. Primarily the commercial release of Relativity Air for review, which is Gen AI review product that's it was originally announced, last January or something, a year ago, something like that. And has been in testing with customers and came out for commercial review. Anybody thoughts, comments, impressions of that?
Yeah, I guess Related to that, I thought an interesting conversation I had about the product. So obviously it's, some folks have been working with it for a while, but not this is kind of the big release. Interesting thing about it I found was listening. I went to a panel where, Foley and Lardner, who's, long time, maybe even the first, I think, maybe customer, was talking through how they use this. And a theme that has come up in AI usage generally, not just in e-discovery, has been the number of people who use it in parallel with humans. They keep humans around, keep humans doing the same task as a redundancy factor because they don't quite trust AI yet. And as this one panel, not just Foley and Lardner, but as these firms talked about their experience, they talked about how they were doing that. They absolutely had humans doing it as a check. And over time, it became obvious that this was a waste. The humans were making more mistakes. The humans were slower. The AI was great. There was no reason for them to keep doing that. And that level of confidence takes time to get, because nobody wants to turn over everything to the algorithm quite yet. But those narratives, I think, are going to become increasing and increasingly important to hear from other customers that they've been through it. They also were skeptical and had their humans around, and they also learned that they didn't need it. And as that happens, the runway is going to shorten as future people get into the product. They won't be relying on redundancy for as long as some of the early adopters have.
Yeah, it's kind of interesting that think how long it took to gain general acceptance of technology-assisted review. I mean, it's still battling that a little bit, and to me, it was kind of interesting that we're now introducing products that are supposedly even better than technology-assisted review and easier to work with. And it'll be interesting to see if we have the same sort of pushback and timeframes to get this to be generally accepted.
Another interesting aspect of it, I thought, I was sitting down with Relativity's Kristen Traylor, and she had just come off a panel with law firms too. And the thing we were talking about, and that she was saying she was excited about also, is that for the first time you have like partners or senior lawyers who, for the longest time, have just avoided all these platforms, technology. Like that was the purview of the juniors. They didn't want to get their hands dirty. Now they're so excited about it that they're getting in there and using it too. So you're getting people who have just been so averse to technology. Because not just because, probably they're drawn in because it looks and seems sexy, but then it's the natural language queries you can do it. It's just so much easier for them to use. So you're seeing more people getting involved in the use of the technology than you've seen before with these kind of tools now.
That was my whole point in the e-discovery State of the Union. I don't know if you were there.
I thought that's what you were just going to say, and you didn't say it. So I'm like, okay, I'll say it then.
Yeah.
You know what? Go ahead, Bob.
Just to go back to something Stephanie said, because it does raise some really interesting points, because the senior lawyer in charge of the case typically will know the case the best, will know the overall strategy and vision the best, will know the client the best, and would be in the best position to formulate queries to the documents if they could do it in a natural language. And these tools will allow that. But the flip side of that, of course, is what does that do to the leverage model in law firms? Because now you don't need the associates and the paralegals to run all these searches and review all these documents. I can do it myself in half the time, or a tenth of the time. So we are on the cusp of a lot of changes, I think.
So Relativity is going to be forcing a lot of law firms to lay off massive numbers of employees. Is that what you're saying?
No.
No, I believe he said Relativity.
Comment on that, David?
All right, well, so.
Relativity has killed the billable hour, I believe, is what Steve just said.
Well, we can talk a little bit about human cost, because I don't think that law firms are going to be laying off bunches of humans, but there is going to be a decreased need for the human contract attorney who has been reviewing kind of brute force review. That is a job description that probably will reduce significantly as these tools get better.
I think one thing, and of course I have to walk a fine line here in that I'm wearing the journalist hat today, so covering that, and I am not representing Relativity here. But to Steve's point and to Stephanie's point and Joe's point and Bob's point as well, The black box was a real issue with tar, and you talked about this one being better than tar. You put stuff in there, you didn't know what it was. With what you've got with relativity air and when you're using generative AI, it will tell you why it's making its decisions. That is a huge difference. And I would argue that people aren't going to get laid off. Someone's going to interpret that. If you had that senior attorney come down and he said, okay, here are the tar results, and how'd you get them? Black box. But if he's got to interpret what the AI is doing because the AI is telling him, that's a job for a human. And there are going to be humans who have to interpret these results. And it goes into a lot of ways. They talk about McDonald's. They thought that the ordering systems were going to put people out of jobs. What it did was it made people order more cherry pies and more Big Macs and more French fries. And so then there were more people needed to make those French fries, cherry pies, and Big Macs. So I think we're at a dawn of a pretty exciting age and big question marks on what it holds.
Yeah.
Also sort of a terminology thing here, or you just made me think of this because I recently interviewed Jeremy Pickens, who's a computer scientist at Redgrave Data, which another story we might talk about today. But part of Jeremy's argument is that whether you're talking about generative AI assisted review or machine learning assisted review, it's all tar. The tar, it's still tar, it's just a different technology, but it's still tar. So I mean, when we talk about tar, we can continue to talk about tar, but with different tools. I think one of the interesting questions about this technology, and I brought it up at the media briefing we had the other day with Chris and Phil, was the question of to what extent the GAI review is actually going to replace the traditional machine learning review, or to what extent they're going to just kind of supplement each other or build on each other. Does Gen AI eventually just completely replace machine learning as a review tool for e-discovery? Their answer, I thought, was kind of it depends. The way they answered it was it really going to depend a lot on the user.
I think your mic is low. You want to switch?
Is it off? I don't have it high enough. Okay.
Just hold it higher.
All right. Okay. Now I can hear me.
Now we've been heckled by the audience. So.
Yeah. All right. But their answer was really that it's going to depend a lot. The different users are going to have different patterns of how they use these technologies and how they use them together. But I thought that was an interesting point. By the way, Olivia Mulvey, as you're watching this, is there anything going on in the chat that we should be aware of out there?
People think that David sounds like Jeff Goldblum.
There we go.
Well,
Well,
definitely
that's
that.
yeah,
We all
that's
know he
true.
has the best voice.
It's the last time we have him on this show.
It's really everyone's commenting on how nice it is to see you all together here at Relativity Fest.
We do really like each other in real life, y'all.
We're still waiting for that RV. Anybody who wants to get us an RV, we'll take it on the road, but we're good.
We'll be everywhere.
There's some debate. So Fred Lambert commented the only counter to the Mickey D's story is that at the same time sales at locations open at least a year fell 1% in the April to June period. The first decline since the final quarter of 2020, when the pandemic shuttered stores and millions stayed home. In the U.S., same store sales fell nearly 1%. So there's some debate in the chat about the McDonald's story and cherry pies.
The important stuff.
Yeah,
Okay.
exactly. So
Very-
I've
very legal
led us down the
technical.
primrose path, and Jeff Goldblum,
I
was...
mean, that's a great comparison.
Yeah, it's almost as good as another one. I was moderating the judicial panel at University of Florida, and the dean came back and said, you're a great Oprah. I'm like, oh, Oprah, okay, I'll do that. Yeah, she's a great interviewer. But, well, interesting. So Greg's got better data than I do at McDonald's, so we'll leave that. But we were just talking about this the other night. I used to work for McDonald's, and an alumnus of that corporation. Cheeseburger 10 quarters, sir.
Awesome,
Every time
awesome.
I am with David, he pulls out another job he's had in the past in his life. It blows my mind. We'll drive by something. It was like at Ilticon. That's when you were like, oh yeah, I used to work at McDonald's. And we drove by another store. He's like, I used to work at that. I'm like, what have you not done?
Good idea. Our chat monitor now has a microphone, so
Oh, very good.
we could just spend the rest of the show reading the chat, and we can just shut up.
Olivia Mulvey's got it under control.
Well, not really, 'cause now it's frozen for me, so I can't see
You
the
froze
chats,
again?
but
I jinxed you, sorry.
All right. All right, well, anything else about Relativity Fest?
Yeah, I mean, I am interested to see the other features of AIR that are rolling out in the future, the AIR for privilege and the AIR for case strategy, especially case strategy, but also AIR for privilege, because I mean, if you don't agree that that priv logs are the devil, that means you were never actually a litigator.
Right,
I don't
yeah.
believe you. They were terrible. So just seeing that ability alone, let alone the more in-depth capabilities of that, I think is going to be huge.
You know, as somebody who had to go through priv logs a lot, I don't really mean it the way I'm about to say it, but the substance of the privilege log aside, just having it be one consistent voice for the whole thing
Yes.
is worth it. Like the most obnoxious thing about a priv log is where you can totally tell it's now moved over to some other lawyer
Yes,
writing
yeah.
the
Yeah,
description.
absolutely.
Yeah, I think, I think it's also fair, it's important to say in fairness that obviously other companies are working on pretty much the same things. Joe, you and I were talking about this the other day, about this came up also during the press briefing we had. And you're probably going to be seeing all the major legal e-discovery companies moving in the direction of developing Gen AI review products and Gen AI priv review products. And I think a lot of it is the devil's in the details in terms of how you execute it, what the user interface is like. Phil Saunders, the CEO, made the point of wanting to be very deliberative about rolling it out, that they didn't want to kind of rush it out the door. They wanted to make sure it was tested and tested it with customers for a while and got it out there. But this is really what we're going to be seeing. In the e-discovery front, we're going to be seeing kind of this new war over the next year or so in terms of Gen AI tools and review and priv and case strategy and all those things.
Yeah, I should have been more specific, more clear that any product out there that is going to get rid of priv log madness, I am all for. I am on board.
Absolutely. Before we leave Relativity Fest, I think, we would be remiss if we didn't mention those of us, at least 4 of us here, went to a press briefing about your access to justice and your programs to help provide aid to those that are working on social and racial justice projects. And David, not to put you on the spot, but I think it was a very worthy and worthwhile project, and I think maybe our listeners would like to hear about it, if you could say a few words.
Sure, and I'll keep it brief because I know we have other topics, but this is a really important one. We started doing this years ago before we had a formal program, and a lot of you have heard this story before, but we had James Sandman, who is the president of the Legal Services Corporation. He's now president emeritus. He's moved on to University of Penn Law, and we brought him in. And we had Monica Bay, a colleague of many of us here, and it was the 3 of us talking access to justice. Tom O'Connor wrote an article about it 2 days later entitled, "The Best Session at Relativity Fest No One Attended," because we had 8 people in the room. And since then, the idea of access to justice has gained steam. And there's a huge commitment at Relativity to it. The Justice for Change program, we had Beth Clutterbuck, who is our Chief Human Resources Officer. She's also the executive sponsor of Social Impact. And she talked about exactly what Steve's talking about, what Relativity does to give back and give free technology. Isha Marate, Stephanie's colleague, was on there, and Stephanie talked about the impact that technology could have on access to justice. Bob, you've spoken eloquently on this, technology levels the playing field for a lot of people, but there's also the idea how much it costs, and that brings in the relativity part. But also on that panel, we had Judge Michelle Rick of the Michigan Court of Appeals, and she had her law students from Detroit Mercy Law School there, and it was great to have the students in there, but they are really interested in this. She gave her triple perspective from the National Association of Women Judges, the court, and also from her law school class. Dr. Victoria McLeod was there. She, of course, you saw her on the judicial panel, but she talked about the costs in the United Kingdom, the loser pays system, and how cost shifting works. And then, of course, someone who's been here many times, retired U.S. Magistrate Judge James Francis. And Judge Francis is now with JAMS, is a neutral, and talked about the effect of arbitration and mediation. And one thing I left out of his bio is that he was a public interest lawyer before he actually went to the bench.
And he had no qualms about correcting you on
No,
that.
he did not. No, he did not. And it's been great working with him for so many years. Look forward to many more. But when you get all those perspectives in the room, talking about how can technology do it? How can rules do it? How can alternative dispute resolution help? And it's great to see everyone interested in that topic, and hopefully we can get more interest in it.
To be wildly cynical, one of the
Never, Joe.
unsung, yeah, fair enough. To be one of the unsung powers of generative AI in this space is going to be the big firm pro bono world, because there's going to be an acceleration of how quickly you can handle things that will tell people who, this is the cynicism, big law people who are like, we love pro bono, but we also don't want you to waste a bunch of time that isn't billable. With the increasing speed in which you can do things, there will be more opportunities for them to say, okay, you can do this.
And it's not just the increased speed, it's your ability to handle things that are not in your bailiwick. You know, one of the drawbacks to doing much pro bono work is you think, oh God, I'm a transaction lawyer. What do I know about, you know, custody disputes? You think, I'm not really qualified. But with these tools, you can at least get, you know, so workman-like knowledge about various areas.
Well, and it also like gets you the experience, because I remember like when I was, you know, a junior associate in big law, like the only people who had any sort of trial or deposition experience in year 1 or 2 is because they happened to land on a pro bono case.
Right.
They weren't going to be being given that opportunity otherwise. So, I mean, I think that's huge too. And I agree. I mean, like I've talked about this a lot, where you know, every law firm says they do pro bono and reward up to how many different hours, depending on it is. But I'm like, but do they really encourage you to take advantage of that? Or are they just like, so for some, it's just purely lip service? So I'm like equal cynicism with you on that part.
There are definitely big law firms where you can see that there are outliers. There's one person who works almost exclusively on it, driving up numbers, and then others aren't, you know,
I've always wanted somebody to like dive into data and be like, okay, for the people who have maxed out their 200 hours a year or whatever they're allowed to do on pro bono, are those the ones that actually like stick around and make it to partner? Or are they the ones that are like more quickly like out the door?
To have a Pollyanna, sorry, Bob. No, just to have a Pollyanna look at this sort of thing, there are firms that have a partner dedicated to public interest in pro bono. So some firms definitely are making a legitimate effort at it.
Well, it's funny. Like I was saying, the people that got the experience early as junior associates, like one of them was my good friend Scott Fishman. We were at LaBeouf together, and he has since been that exact role, and now he's at Shook, Hardy, and Bacon as their director of pro bono. So he became a partner and a pro bono manager because he was one of the ones early on that got the experience.
We have a live audience member question or comment.
All right.
Love it.
I know at least 2 big law firms who have a driving commitment I've seen over multiple years, where they're trying to get pro bono every single attorney.
Yeah.
They want every single attorney to do a minimum point of pro bono, and they're very serious about that. So at least in some ones, it's not just, you know, can you do it?
Oh, for sure.
They want every attorney doing it.
Yeah, and then that speaks to Steve's point of like, if you're an ERISA lawyer, what do you know about handling this? But these things could certainly help you get it done.
Well, and the other thing that I think could be interesting to sort of come together on this is like, I'm aware of 3 big law firms that offer an innovation credit, whether it's 50 hours or 100 hours of like the equivalent of billable time for doing innovation initiatives and AI initiatives and things like that. And if you can combine the AI with the pro bono hours, I could see that actually, I'm hoping more firms do the innovation credit as well. But I think like sort of mushing those together could be a really interesting thing for firms that want to encourage both aspects of those. I mean, maybe net it'll be fewer hours if you can push them together.
Right.
But I think there's a real opportunity there too.
Well, I think we can move off of how big firms are using generative AI and talk about how generative AI can be used to directly impact consumers by providing tools that consumers can use to solve their problems. Companies that are examples like DoNotPay, for example, right? I mean,
Oh, what a transition, Bob.
How about the Federal Trade Commission?
The chat actually does want to go back to some generative AI talk, it seems. So Jonathan A. Franklin says, naive question, if generative AI is available to all vendors, how will e-discovery vendors differentiate their product from each other going forward? And then I'll just include some comments in the chat on that. Greg Lambert says that the value add with generative AI isn't what it brings back, but rather what are the products doing before, during, and after the generative AI tools are engaged. Everyone is using the same 3 LLMs. He lists some there, but the LLM is just a piece in the process, and the differentiator is going to be all the other pieces that the product does with the information input and LLM output. And then Michelle says, agreed, Greg, automation plays an important piece in that. Generative AI on its own will only get you so far.
Yeah, I mean, for sure. I mean, there are, there's only a small handful of LLMs everyone's using. So it comes down, in my mind, to being intentional of how you're putting them in the products, what you're using them for, what capabilities you build off of them. Because, like, yes, everybody has AI now, and just saying we have AI never should have been enough, and it certainly isn't enough now.
Yeah, I mean, part of the differentiation is going to come, I think, as I said earlier, kind of just in the UI, and who is able to make these tools the simplest and the easiest to use. There are some in the e-discovery space, some products I've seen, one in particular, and I know Joe has seen this one as well, where you can kind of go in and really kind of fine tune which LLM you're using, not just which LLM you're using overall, but which LLM you're using for which part of the task. Like some LLMs might be better for summarization, some might be better for search, some are cheaper, some are more expensive.
Mini is cheaper, and yeah.
And so you can go in and really kind of control what kind of results you want to get, how much you want to spend. But it's pretty, I mean, the UI for that gets a little bit more complicated, and it makes it more difficult to use for some people. But there are a lot of ways to differentiate in this area beyond just which LLM you're using. All right, well, on DoNotPay.
All right.
Do not pay.
We did want to talk
DoNotPay
about
did pay. The FTC in particular.
They did not use a robot lawyer, but Steve, you want to talk about that a little bit?
I thought Stephanie had that
Was
story.
Stephanie going to talk about that?
I mean, sure, I think we all were going to talk about
We're all
it.
gonna talk about it.
But yeah, as Joe said, DoNotPay did in fact pay $193,000 in a fine to the FTC. They say it was related to products that they long ago discontinued, but still, yeah.
When it was exposed that it didn't work.
Yeah, right, exactly. In addition, the order prohibits DoNotPay from making claims about its ability to substitute for any professional service without evidence to back it up. So yeah, I mean, I think, we've talked about DoNotPay on here before. We've talked about Joshua Browder. You've talked to him directly, Bob, and it was like, it's been around for a while. I mean, I remember I wrote an article about DoNotPay when they first came out when I was still at Above the Law. But then it was really, in my opinion, it was all of the stunts that they pulled right when ChatGPT came out that really put them, even if these were products that existed before that, it didn't do for them what I think he thought it was going to do for them. Because, you're offering to like sneak it into traffic court and argue a case, or offering anyone $1 million to argue it before SCOTUS, even though everyone knows you can't like take your phones in there. But it just really, and they immediately then backed out of a bunch of legal products once people called them on that. And so I think this is just sort of the natural evolution of that. And I honestly don't care if there are things that they offered a long time ago. They were still offering people things that clearly or apparently did not work.
I think you brought up an excellent point when you talked about sneaking into traffic court, because Bob, as you know, you mentioned, interviewed Mr. Browder, and my friend Daza Greenwood has had a lot of interviews with him. But I think what the FTC decision is changing a lot is when there was first criticism of DoNotPay, it was, well, it's the old guard, the lawyers, trying to protect their little fiefdom and trying to keep the guild that way. And now you see the FTC turning it into a consumer issue. So I think you've crossed a big Rubicon there.
There's a lot of aspects to that, and Richard Tromaine's at Artificial Lawyer wrote on it. It was kind of, Bob and I joked about it. It's kind of a funny article because he started talking about the FTC settlement and the money that was paid, and then he kind of launched into what the FTC also ought to do is look at state bar associations and amend the rules so that non-lawyers can participate in ownership fashion in law firms, and how that would be a good thing. But then he morphed to what I thought was the best point that he made, and that was, look, just changing the ownership rules in and of itself, that's not going to impact access to justice, and we're kidding ourselves if we say that, because letting law firms have more access to different capital and more capital so the bigs can get bigger, that's not going to help access to justice. What will help access to justice is entities that will use generative AI and artificial intelligence to reduce the cost of various things and to create automated bots that can do some of these tasks that really lawyers don't need to be doing, such as the parking ticket thing
Yeah.
that Josh brought out. And I
Well-
thought that was really a good point that he made. He kind of went around the horn to get there, but it was a good point that he made.
But I think the access to justice point is an important one. So when I was first writing about the year or so ago, their AI stunts, I wrote a very properly journalistically neutral article. But what I was doing is arguing that what they did with those stunts was really had potential to set back the A to J cause, because DoNotPay came out as, like, in theory, a great idea of, like, help the little guy. You don't have to pay a ton of money for a lawyer. You shouldn't have to just fight a parking ticket, right? And it was supposed to give this accessibility to legal services in the hands of everybody. But then now they just, like, by pulling that stunt, they just really, like, I mean, it put a bad taste in a lot of people's mouths,
And
mine
that is what
included.
the FTC said, too. They, as part of the decision, they said that one of the big problems is it undermined confidence in using this for those causes.
We have an audience question.
Why is it okay for for AI to do the review, but it's not okay for non-lawyers to do review? I just don't understand that question. There was a study over 5 years ago about, they had a whole bunch of high schoolers do first-level review, just, what is this about, what is that about? And they did better than lawyers. And so that was a big question for a long time, is, well, why do we have to have lawyers to do it? Now we have AI doing it, and people says, well, they can do it because it's supervised, but the teenagers would have been supervised. Why is that okay? I don't understand.
That is protecting the guild, I think.
That's a good question.
Yeah, I don't know that any of us would say that is okay.
I don't even know that you need to have lawyers doing the review as long as it's supervised by lawyers. I mean, it's a legal proceeding, so you're producing evidence for discovery to in a court proceeding. So you have to have a lawyer overseeing it. But I don't think the people actually looking eyes on the documents, in the old days, sitting in the big storage room somewhere with the file boxes, I don't think they have to be lawyers. I don't know.
Well, it's interesting because I suspect also that they did, but then I thought about it and, like, that you definitely can have paralegals do that in some firms. So yeah, but yeah, we have historically limited that, and I think and had contract attorneys and stuff, and I think that's part of that is the guild aspect of it.
It always comes up with whether that's the unauthorized practice of law. And there's an opinion, can't remember where, but the judge said, well, if it's artificial intelligence that's doing something, by definition, it can't be the unauthorized practice of law because it's not a human.
Steve, that would be Lola v. Skadden Arps, and you can read about that on the Relativity blog from many, many years ago. But I would have a slight dissent from something Steve said earlier, and it's to your point on this, that the senior partner knows the case the best. You're absolutely right. I think the senior partner knows the client the best. They brought the case in. But when you're going through that review, I think there's a big difference between first pass relevance review or responsiveness review and then the privilege review. Why, when you get into what the AI can do on privilege, it's amazing. I would argue that on the facts, you're right. Any reasonably intelligent person who is familiar with it can do the facts. It's the privilege calls and the work product calls that are really difficult. But on top of that, like the iterative process that Gen AI can do, humans do that too. On day one of a review, think about everyone here has done document reviews. On day one, no one knows jack about that case. By day 5, the whole team knows more. By 10, they're becoming experts on these facts. So I think humans do the same thing Gen AI does. And I bet those students, if they had been in those documents for days, they'd know it better than maybe the senior partner, and sorry, senior partners.
Well,
I guess, David, when I was thinking about that, I was thinking not so much of a review of your own documents, but when you sit down and start preparing for a deposition of your adversary, then, I remember back when I was practicing at the tail end, we were beginning to be able to do those kind of searches, and I was able to search that so much more efficiently because I knew exactly sort of the things I wanted to hit in the deposition, and so I could pull them out. So that's kind of, I agree with you on the front end when you're looking at your own documents and trying to figure them all out and get them all out.
And I think you're right, Steve. As the senior lawyer, you were better able to do that than, God bless the high school students, and I think they're great on the facts, but you need Steve Embry to come in and make those final calls.
Not anymore.
But I do think, yeah. But
Thank you for that question.
Yeah, and your question, my final note is your question gets exactly to the core of the argument that many people make that the bars are just, there's too much protectionism going on by the bars. Like with needing to ease up maybe on the UPL, the unauthorized practice of law standards, especially like in light of technology, if we really want to help access to justice too. But your question goes right straight to that.
My insight is I think the reason that the industry is more comfortable handing it over to machines is because that's a way to get rid of an employee. I think that's very big motivation in all of business in the United States is elimination of employees. Ever since the 70s, it's been like, hey, we can reduce all our problems if we just reduce the number of employees. So I think that's the big driver and why AI is accepted more than non-lawyers.
And now you're speaking my cynical
I was
language.
just going to say, I was gonna say that's exactly the
We
kind,
all looked at Joe
Yeah,
when you
yeah,
said
yeah.
that.
yeah, that's exactly the kind of cynicism this panel loves. So yes.
I want to bring that back to the Browder thing again, or the do not pay thing again, only because I think part of Troman's point in his piece on this was that this is potentially a blow to access to justice or to non-lawyer organizations or entities trying to deliver services through technology or other ways. And I don't think this was, honestly. To me, this, if you read the FTC, what the FTC put out on this is really about deceptive advertising. And the fact that DoNotPay was making promises that were not true and not accurate and did not accurately describe what its product could do, and it couldn't deliver on the things it was promising to deliver on. And that was exactly what Catherine Tewson way back when exposed when she went through and tested all these products. She, signed up and tried these different products and found they couldn't do what they were supposed to do. And so this is not, I mean, if a legal tech company is going to deliver services directly to consumers, but is transparent about what those services are and what it's giving them and what it can do for them, and there's lots of companies like that out there, this has nothing to do with that. This is about one company and its deceptive practices, I think.
Yeah, and they weren't, the FTC wasn't focused on his automated parking ticket deal. That was not even part of it. It was what he was trying to represent that he could do that was so broad that, I mean, when we all saw it to begin with, we were going, really? Really?
Well, and it's interesting. I have not pulled up their website since in a while, and apparently in response to a California bar complaint, it doesn't say robot lawyer anymore. It says your AI consumer champion, and they also used to use the tagline "sue anyone," and that is gone now too.
And they even discontinued a lot of those products that were, the ones that Tewson wrote about,
Oh,
they
yeah.
ended up discontinuing the products after she wrote about
they
them because they didn't work.
Yeah, but they still kept the robot lawyer and sue anybody thing. But now, I literally I haven't gone on this in a while. Your AI consumer champion is what they are now.
Yeah. We're getting towards the end of our time here. Was there, Joe, do you have anything else you want to bring up this week?
I mean, look, the only other thing, we don't really have a lot of in-depth for it, but I mean, this was a banner week for the whole short message, social media, texting, the gathering of evidence. We have the mayor of New York through a variety of SMS, encrypted apps, all over the place. We had, from a forensics perspective, we had one of the witnesses leave the room of an FBI interview and then attempt to delete the app, which by the time the FBI is talking to you, they know you're doing that. But it was really a banner week for that aspect. And we talk a lot about Gen AI in legal tech because that is the big new thing. But some of the most interesting conversations I've had this year that didn't involve Gen AI have been about collection and how to get that stuff, how to understand it, how to authenticate it, how to deal with the proliferation of different ways to communicate. And so we have like a mainstream news story that's all about getting electronic messaging and how powerful it is when you use electronic messages to, discuss bribes.
Yeah, for those watching, if we had made a drinking game out of how many times Joe said Eric Adams this week, none of us would be here today with you. So, all of you know him a little bit. You can imagine he's been a bit riled up about this.
Isha was mentioned, Stephanie's colleague, and yeah, Isha and I have a side chat where we've just been pulling things from the complaint and texting them to each other because every paragraph is more crazy than the last.
Oh yeah, I haven't even read the whole thing yet, but every little snippet that comes out, I'm just like, Oh my gosh, yeah.
He did say last night when he was being interviewed that he really did it for his constituents.
Yeah, I mean, he's being
As-
targeted.
He's
As one of
sacrificed.
his constituents, I kind of call shenanigans on that.
Yeah, one of his constituents who happens to live in Ankara.
Yeah.
There was another story, right?
Well, the only other story, I mean, Steve, do you have anything else you want to bring up? The
No,
only-
we-
I was just going to mention the Wolters Kluwer.
Yeah, go ahead. Yeah.
They been a lot of talk on this panel over the last year about legal research companies putting out their generative AI products. Wolters Kluwer maybe is perhaps last to that game right now. I just released its VitalLaw AI this week, its own version of a generative AI legal research product. It's probably one of the interesting features about it is, and this has been a theme in a couple of other AI products we've talked about, the human element, which is that it's got what it's like a lot of these generative AI features. You can ask it a question, and the generative AI will generate an answer to the legal question with pointers to the different sources that it based the question on. But it also has a whole library of human-generated answers. So if you happen to ask one of the questions that it's already prepared a human-generated answer for, it's not going to give you the AI-generated answer. It's going to go straight to the human-generated answer. And I think that's really interesting, and it's kind of a way of building on their own expertise. I mean, Wolters Kluwer is much more focused legal research service dealing with very specific areas of law rather than everything out there under the sun. So kind of an interesting take on it. We'll see how it goes. Also going back to the point I made earlier about even with relativity error, is that they kind of they kept making the point they were kind of very deliberatively thinking about how to roll this out. They didn't want to kind of rush something to market, spend a lot of time building it, testing it with customers. So I think that's a good approach for companies to be taking, and I'm kind of glad to see that.
We've seen several companies that took the other approach. by the
Yeah,
way.
exactly. Yeah,
Even while they would tell you that they weren't.
right. Or they make a big splash. We also have the ones with the big splash that don't have a product yet.
Yeah.
But
No.
yeah,
We don't
that
get
hasn't
any of
happened.
those announcements
That
to
hasn't
announce
happened.
things, no. I thought Steve was going to talk about Rocket Lawyer. Weren't you?
Oh yeah, Rocket Lawyer.
Oh,
Forgot about Rocket Lawyer.
Well, yeah, we're kind of
What
running
do we
over,
got?
but so.
we got 5 minutes.
Rocket Lawyer got approval, a couple of days ago in Arizona for its subsidiary to create a legal services provider that was not owned exclusively by lawyers. And I think that maybe was the first one in Arizona. They've also had one in, no, it's not the first one. They also, Rocket Lawyer got approval in Utah, I think, and also in the
Washington
UK.
State?
No.
Okay.
But, looking at it, Rocket Lawyer, they primarily serve like small businesses and individuals with sort of business problems. But that's not to belittle what they've done, because that group of customers in the legal field is huge, and many of them are not served. I mean, many businesses, small businesses, go without legal help because they can't afford it. The margins are too thin. And so, yeah, I think it's a good thing. And, if it were, a giant law firm that did that in Arizona, I'd be skeptical. But Rocket Lawyer is pretty committed, at least to serving that market, not necessarily serving the total underprivileged market that maybe, also needs a lot of help. But it's a good thing.
According to the article I'm looking at, it was Utah, Arizona, and the UK where they've done it.
Okay.
Yeah, they've been in the UK for a while. They've been doing
where
that,
they-
and
where
and
they
they
got
were
these
already. They just got approval in Arizona, but they've already been in Utah. They've been in the UK for a while. There have been other entities. There've been some ALSPs that got approved to open law
That's right,
offices
yeah.
in Arizona, and
You're
there was
right, yeah.
actually an e-discovery company, Logical, last year opened a law office in
Right, you're right. I remember
in
that
Arizona
now.
just to kind of focus on providing services relating to e-discovery matters. So, but it is interesting, and Rocket Lawyer is uniquely situated to do that kind of an offering, I think, in the state. So, David, any last words?
Just thanking everyone for being here, all of you for sticking around to the very end, and appreciate the coverage, appreciate your being here, and thanks for letting me be a part of it.
All right. Well, this
Thank
is
you to our audience out there that asked some good questions.
Yay.
And Olivia
this
for
is
your
this is a little bit of a
intermediary.
preview. Go ahead.
I was going to say, and thank you to Olivia for your intermediary for representing the comments section.
Exactly.
You're very welcome. I hope I did the comment section proud, but I did lose internet multiple times, so I'm not sure if I got everything.
All right, well,
Right.
and just, if you're going to be at CleoCon, we're going to be doing this again live at CleoCon, not David, unfortunately.
Darn.
But we're going to be doing a live panel at CleoCon. I don't think we're going to be broadcasting it, though. It's going to be just in front of the audience, I think. We're going to record it and maybe put it out
Yeah,
after the
record it and
fact.
put it
but-
out after.
But yeah, this was our warm-up for that. And so if you're at CleoCon, watch for us there. And thanks, everybody, for watching. We'll see you back next Friday, same time, same place.
So
Well,
long.
not the same place.
Not, yeah, not
Wait.
that place.
I hope not.
Because that's what I would do on Zoom. I'll wait.
Same too, I would think.